My name is Hope Shimabuku, and I am the Regional Director for the Southwest Office. I have been with the USPTO for almost 10 years, and prior to that, I was a practicing attorney for 2 Fortune 500 companies, as well as a couple of law firms. But before I move forward, let me tell you the brief disclaimer that we have. Just note that today we are only providing informational for informational and educational purposes. We are not providing legal advice. And so should you need legal advice, we ask that you consult an appropriate source for legal authority and guidance on any of the matters that are discussed today. And so with that, let's move forward. So today we have a couple of objectives. I'm going to go over a quick recap of a couple of the things that were talked about in previous sessions. And then we're going to dive deeper into the claims itself. We'll start with claim fundamentals, and then we'll talk about some examples, and then we'll also move into some common issues with claim language. So first, a quick recap on some of the things that were previously discussed. Provisional versus non-provisional. Remember that a provisional application means maybe. A provisional is a maybe application. It's not a full-blown application, but it's a maybe application. And it applies to two different types of applications, specifically utility and plant applications, but it does not apply to designs. Provisional applications are really a placeholder in time, and what it allows you to do is to be able to give you a placeholder in time 12 months earlier than when you actually file a non-provisional application. The reason a provisional application is beneficial is because when you're filing an application, it's really a race to the patent office. And whoever files the application first in the office is the reason, or is the person who actually has the benefit and is able to possibly patent that. And so because of that, a provisional application is something that you can do in order to put a placeholder in time. It allows you to establish what we call a priority date up to 12 months earlier than a non-provisional application, and it's relatively inexpensive. But remember, a provisional application will never turn into a full-blown patent. You have to file a new non-provisional application in order for that to happen. Provisional applications just don't have as many requirements with respect to content, but a non-provisional application has all the requirements that are needed for it to be legally turned into a full-blown patent. Provisional applications have no claim requirements. Remember, they are abandoned after 1 year. And it just gives you a little bit more time, especially some inventors, for you to decide if you want to spend a little bit more money to file a non-provisional application. As I mentioned, a non-provisional application are the applications that actually become patents. Claims are required as part of the non-provisional application, and that's what I'm going to be spending a lot of time discussing today. What is a claim and how do you draft claims? And then just a little bit of a reminder, claims must be fully supported in the earlier provisional application in order for you to claim benefit or the date of the non-provisional application. So these are the requirements for a disclosure for a non-provisional application. Disclosure is the entirety of an application, including the claims themselves. What's included in a disclosure is the written description, abstract, drawings, and claims. And if you want to know more details about a disclosure and what is included, please refer to the Manual of Patent Examination Process. Short is MPEP, but specifically section 608 that talks a little bit more about what's supposed to be included in the specification. Now, let me talk a little bit about the word originally filed that is listed in the title. Originally filed is the determination of what we call the filing date, which guides the examiner in determining what sources or what prior art would apply to that particular patent application. The examiner needs to know what the inventors were in possession of when they filed their application. So for example, is that subject matter in the provisional maybe application, or is it in the non-provisional application? That determines the date of which the examiner will look for prior art. And in order for the examiner, or in order for the inventor to prove what was in their possession, they should have enough details to describe how to make and use the invention, and should include full and definite terms that communicate the invention to a person of ordinary skill in the art. So ordinary skill in the technology or in the art usually refers to someone with a little bit of experience. So for example, I wouldn't expect someone who's never swam before to understand the terms used for practice drills. So if your invention is swimming related, you'll write your description for someone at the level who is another swimmer, rather than someone who is completely new to the sport. And so that's what we talk about when we're talking about person having ordinary skill in the art. So when you are writing a written description, there are a couple things that you need to keep in mind. One is that if you invent a structure or device, you should explain what that device is, along with all the parts that make up the device. Your drawings, while not mandatory, but are highly recommended, they should clearly show each and every claimed part of the device structure. If you invent a process, you should explain the steps and methods of your process, and your drawing may be a flow chart for the method or the process. And if you invent some composition of matter, you should explain the composition with details like the different layers or each of the molecules and how they're interrelated. And sometimes with chemical diagrams, those are things that would aid in describing the invention and should be included in the invention. Make sure that all the terms that you use in the claims can be found in the written description, because that there has to be a clear nexus between the claims and the description. And that nexus is what we call antecedent basis. And I'll be talking a little bit more about what antecedent basis is later in the presentation. So let's talk a little bit about drawings. Part of your disclosure includes the drawings, and they should use figures and drawings when necessary to understand the subject matter that is being patented. Now, as I mentioned, drawings are not necessary and they're not mandatory, but they are very, very helpful in understanding everything. And then a drawing is necessary a lot of times to understand the invention. And please note, you can't introduce a drawing, a completely new drawing, after you file the application. So if you have a drawing, they are very helpful tools to explain your invention to both the examiner and the public. And it's important to know, if you did not include the drawing at the time of the filing, you can't add it later. You can make amendments or modifications to a drawing that is already existing there, but you can't add a drawing even if you accidentally omitted it. And drawings are necessary for you to have needed to understand a feature of your invention. If the drawing is, you can't add the drawing later. You can add replacement drawings, which are amendments really to the original drawing if there is some error that is in there, but you cannot add something that is new. And remember, the USPTO publishes things in black and white, so please file your drawings in black and white as well. One thing that I want to note is that all your drawings must show every claimed feature and the claimed invention. And it's good practice to not assume that the examiner is able to know what is behind a certain angle or orientation of an invention. Drawings should include all the views and they must be separately labeled. And the tools used to clearly show physical structures can also be a cross-sectional view or a dotted line hidden view showing hidden features. And so for more information, we highly recommend that you go into MPEP section 608.02 to find out more information on the requirements for drawings. All right. Now I'm going to actually dive into claim fundamentals and examples. And so I'm going to dive into the crux of our application, which is the claim. So the claim is actually the most important part of your application. The claim is really a legal description of your invention. And it describes the different aspects of your invention, and this is the piece which is legally enforceable. A claim is actually where you draw the metes and bounds or the boundaries of your invention. So it's really important to know that whatever is in your claim must be supported in the written description and the drawings. The written description and drawings goes hand in hand with the understanding of the invention. And so every word in your claim will be given a plain meaning or the broadest reasonable interpretation. And that is actually found in your specification. You can, as an inventor, be your own lexicographer, meaning that you can actually come up with a brand new word if you want, or a brand new definition for a known word. And if you do that, you do actually have to define it in your specification. But as the inventor, you have the opportunity to become what we call your own lexicographer. But please remember that you have to specifically define it in your specification. Otherwise, we will apply the plain and ordinary meaning of that specific word if it is not in the specification itself. So some basics when it comes to form and formatting. So let's look at the specific details about, oh, excuse me, I am having some problems with the mouse. Okay, let's go back to that. So let's go back to some of the specific details about the formatting of the claims. So starting off, the claim should be included on a separate sheet, and there has to be a clear header. And so that header can be claim listing or claims. It is required to be spaced out as 1.5 or 2.0 font. Okay, I am really having problems with my mouse. I apologize. It needs to be 1.5 or double space, and all of the claims should be single sentences, where the sentence begins with a capital letter and ends with a period. Your claims actually have to be numbered consecutively in ascending order, and the original numbering of the claims must be preserved throughout the entire prosecution. So for example, if you originally filed claims 1, 2, and 3 and decide to rewrite all claims 1, 2, and 3 claims completely, you can amend the claims 1, 2, and 3 instead of completely rewriting them, or you can cancel claims 1, 2, and 3 and add claims 4 and 5 and 6. But what you can't do is first cancel claims 1, 2, and 3, and then add new claims as 1, 2, and 3 to to claim your invention. Once canceled, claims 1, 2, and 3 no longer exist at all for the entire period of prosecution or the period as you are trying to negotiate the patent application before the USPTO. So now the claims also need to include a correct status identifier. And that means that you need to clearly state whether you are adding, canceling, amending, or withdrawing the claims. And you actually have to put that status in parentheses next to the claim number at the beginning of the claim. So when you amend your claim, you would also need to adhere to matters of form, where you would underline added text and strike through any removed text. So now moving on. Claims are actually written in independent or dependent form. And if necessary, you can add dependent claims to further limit your independent claim. A dependent claim refers back to the independent claim and incorporates everything by reference that was written in the actual independent claim. So for example, claim 2, depending on claim 1, includes all of the limitations in claim 1 and the limitations of claim 2. Now, the phrase further limit just means that you are narrowing the scope of your independent claim. An independent claim, for example, can be a house, while a dependent claim could be a room in that house or the type of window or siding material or any of the number of stories within that house. Please note that the number of claims does affect how much your fees are going to be before the USPTO. So additional fees are required if you have more than 3 independent claims or if you have more than a total of 20 claims in your patent application. So a couple things to think about as you are trying to draft your claims. And so here's a couple of tips. So the first thing that you really need to ask yourself is, what are the critical elements of your invention? What is the novel piece of your invention, and what is completely new that no one else has come up with? And so those critical elements, the novel piece, should be included in your claim. So if your invention is a device, you should establish the critical elements of your invention and then describe how the elements relate to one another. If it's a method, your claim should include the necessary steps to achieve the end result. Again, you should always have your invention in mind when you are writing your claims. This is the legal documentation of your invention. It's the legal description. And so there are several different statutory categories of an invention, like if it is an actual device, a method of using a device, or is it a method to make the device? If your invention involves all 3 of these, there could be more than one invention in that particular application. So let's take an example, and let's take an example of butter churning. One invention could be how to make a butter churn. A second invention would be the butter churn itself. A third invention could be the method of the steps of making the butter using the butter churn. And then a fourth invention could be a method of washing clothes in butter churn. All of those are distinct and different inventions. And then while you are able to disclose each of these inventions within one application, in some circumstances, if the examiner determines that they are all different inventions, then they may request that you split the inventions into separate applications, and that is called a restriction. So let's talk a little bit about your claims and thinking strategically with respect to your claims. The ultimate goal of your claim is to be able to get the broadest claim without infringing or reading on anyone else's invention. And so it's important to know that as you're going through this entire process, it's not a one and done process. There will be a lot of back and forth between you as the inventor and us as the USPTO office. And so based on my experience when I was attorney, there were often times in which there was a lot of back and forth. And there was very rarely, actually never, when I was an attorney, was there a time in which all of my claims were accepted the first time around. And being accepted means that it is allowed. Now, there are circumstances in which examiners do allow claims the first time around, but most of the time, more often than not, changes are necessary in order to be able to modify the claims based on the information that the examiner has found. And so after you receive your first office action, you'll have the opportunity to make changes to your application, and those changes are called amendments. And you would submit these amendments, and the examiner is able to respond to that in what we call a second attempt. So this back and forth between the examiner and the inventor is what we call prosecution. So think about, at the end of the day, what are your goals that you want to accomplish with your claims? Just remember that throughout the prosecution, the scope of the invention could change based on the prior art search that the examiner does. You may be get presented with prior art from an examiner that makes you lean more towards one embodiment or the other, or it may also require you to change some of the scope of your claims based on what is being presented. In some circumstances, as I mentioned, you may receive an allowance, but you may also decide that the claims are too narrow to be useful to exclude others. And so as a result, you may also still want to amend those claims. So when you're looking at the claims, there are a couple things that you really want to think about. And as you plan to write your claim, what best reflects your invention? Drafting a claim is what we call an art. You don't want to be too specific because it may not provide you enough value at the end of the day to be able to get the protection that you really want. And it's really easy for others to get around that claim. But on the other hand, you don't want to be too general, because if it's too general, not only is it going to be covering possibly other scope of other applications, and you may be infringing on someone else's application, but you may not be able to get the application because it's already known in the field. Additionally, having something too general may elongate prosecution. So you want to find that sweet spot right in the middle where you have the broadest coverage that you can get, but it's not too broad and it's not too specific. So a good strategy to kind of think about as you're laying out your first claim is to write out your full invention as the claim first. And then after that, break it down into less specific dependent claims that would actually narrow the independent claims. And we'll talk a little bit more about independent and dependent claims and show you a little bit more of an example later on to break that down even more. This graphics is actually a great depiction of how you can visualize the usefulness of your claim. And so keep this in mind because we may refer back to this later. Another thing to think about as well is to think economically about your application. We're all on a budget, And so, unfortunately, prosecution and the preparing of the application is not free. When you're actually filing a non-provisional application, you are required to pay a basic filing, search, and an examination fee. The basic fees include up to 3 independent claims and 20 total claims altogether. Now, these fees can actually be mitigated by applying for a certain entity status if you qualify, specifically a small or micro entity status, which will reduce your USPTO fees. Now, remember, this is just USPTO fees. It is not your attorney fees. So, including any claims more than 3 independent claims or 20 total claims will automatically incur extra fees. And those extra fees are applied at any point during the prosecution. So if you add them as you are trying to answer amendment to your application, that could be something that is incurred later versus at the filing if they are new and additional fees. So if you add a 21st claim and forget to cancel a claim, for example, in the process, you will also be charged a fee. So as of October 17th of last year, 2024, each independent claim in excess of 3 is $480 for a regular entity, $192 for a small, and $96 for a micro. And these are subject to change, so please refer to USPTO.gov for our latest fee schedule. While we're on the subject of fees and money, I just wanted to let you know that USPTO is actually entirely fee funded. So they are paid entirely by the fees of all of our applicants. We do not rely on taxpayer revenue for our funding. And so the USPTO also accepts applications from and grants patents to anyone in the world. And US citizenship is not required in order for you to get a patent from the USPTO. So many people actually ask us what is actually a regular, small, and micro entity, and what are those fees? Those specific fees can be found on our website at the link that is listed at our website at www.uspto.gov. And so specifically, you can also refer to MPEP 509.02 to 509.04 sections to find out more information on those fees. But in order to qualify as a small entity, small entities are defined as a nonprofit or a business. Oh, goodness. Small entities are defined as a small entity or a nonprofit and a business with less than 500 employees. And they have no legal obligation to assign the invention to another business that would meet the requirements for a regular status. Micro entities tend to be inventors, and they are not serial applicants. And so as you can tell, if you have applied for 5 or more patents, you may no longer qualify for micro entity status. As a reminder, the dollar limit does change as it is based on a certain percent of median income. So please keep that in mind as you are looking at your micro entity status, and check USPTO.gov for an accurate dollar limit. As another reminder, whether or not an inventor qualifies as a small or micro entity status, this status does not affect your fees for attorneys. Unfortunately, applicants are allowed to file without legal representation, and there are several programs that I will talk about that will allow you to receive pro bono help if you qualify. So for those of you who attended part 1 of this series, this slide should actually look familiar. And I'm bringing this up so we can talk through this as we talk about USPTO fees as it refers to the examination process. The basic filing and examination fees includes 2 proverbial bites at the apple. In other words, 2 attempts to get patented. You'll notice in this that there is a number 1 and 2 in the slide. And so these are where we consider those attempts. The first attempt is the original filing, okay? So the original filing goes through pre-exam and to make sure that all the forms and parts are complete and that the drawings are reproducible. Then the examiner is going to consider the application, do a prior art search, and then send a non-final office section along with a list of cited references. Any responses that applicant does is included in his filing and examination fees. However, what an applicant does in response to that action is your second bite at the apple, meaning the second bite at the apple, if it does not result in a notice of allowance, applicant will have to pay for an appeal or another round of prosecution or have to let the case go abandoned. We bring this up now as we talk about the economic impacts of the choices made by the applicant. If applicants originally filed claims using the maximum allowed claims, 3 independent claims and 20 total, and claims them with gradually narrower and narrower dependent claims, this helps the examiner and applicant gets the best view of the invention as it relates to the prior art. So an interview before the, an interview after the first office action and before the applicant's response can really help shorten prosecution by getting a feel for how the claim language can be amended to read around the existing prior art. And this is the iterative process, the back and forth that you'll have between you and the examiner. And an interview really helps speed up the process in prosecution and hopefully will save you cost in your budget at the end of the day. So let's shift our focus a little bit and we're going to take a tangible example. And this tangible example that we're going to talk about is associated with an inline skate. So first, we need to identify all the components of the invention. So we have an overall boot, the frame, buckle, strap, and laces, and along with these elements, we have a propagation mechanism, and specifically in this case, they are the wheels. So let's talk about the basic anatomy of a claim. There are 3 main parts of a claim. The first part is a preamble, which is a general introduction of the claim. There's a transitional phrase, and then there's a body. And I'm going to go through each one of these sections in more detail. So let's start with the preamble. The preamble is the introduction in which it defines the category of the invention, specifically whether it's a device, a method, or a composition category for the invention. And aside from actually defining the category, the general rule is that the preamble does not limit the overall scope of the claim, because the intended purpose of the actual preamble is just to refer to the category. And the intended language use or the functional language of the preamble generally doesn't contribute to the patentability of the claimed invention. So for example, a boot for exercising is still a boot regardless if it's used for exercising, skiing, scuba diving, or hiking. The term for exercising is considered what we call intended use. Another function of the preamble is that a dependent claims preamble must cite to the claim from what it depends on, the independent claim. So in the independent claim, it should be written as a boot, and in the dependent claim, it'll be written as the boot according to claim 1. So moving on to transitional phrases. So the transitional phrases actually defines the scope of the invention. And there are a couple of different transitional phrases that can be used, but the two most common ones are the ones that are actually listed here, comprising and consisting of. So with comprising, this is what we typically call as an open transitional phrase, which means that the invention includes the elements, but is not limited to the elements that follow it in the claim. This matters during prosecution as well as the post-allowance infringement issues. The scope of the comprising claim includes those elements that are listed in the claim and can include more than those essential elements, which means that an examiner can look for the prior art that includes those essential elements, but the prior art can also have more structure or more features. Consisting of is considered to be a closed transitional phrase, and that means that the elements that are listed in the claim can only include those elements, nothing more, nothing less. The scope of the consisting claim is pretty much the opposite of the comprising claim. A consisting of claim cannot include anything more. And this matters again in prosecution with the USPTO as well as post-allowance infringement issues. So let's talk about the body of the claim itself, which is the bulk of the claim. And these include all the essential elements, steps, or relationships that define the invention. This is where the limitations should use phrases or terms that have clear support in the specification. The body can also set up antecedent bases. Remember that phrase that I mentioned earlier? But antecedent bases for terms that appear later in later dependent claims. You can also use the body to introduce new elements or steps by including transitional phrases such as further comprises. So let's talk about antecedent bases a little bit more. This is something that I had mentioned in our earlier slides. So the first time a claim element is introduced, it must be preceded by the indefinite articles a or an. Any subsequent reference to the limitation should be preceded by the definite article the or said. Antecedent issues regarding reciting a part with a part or the part in the claims are typically drafting oversights and can be corrected by amendments, but the examiner will be pointing these out in the application. So let's identify all the key components that are associated with this specific skate. We have an overall boot, which includes a frame, buckle, strap, and laces. And then along with these elements, we also have a propagation method or wheels. So let's look at an example claim. So an example claim for this inline skate could be a boot comprising a frame, at least one fastening mechanism, and a propagating mechanism. So we can see that the preamble is a boot, and then the transitional phrase is comprising. So we have an open-ended transitional phrase, meaning the claim can add more structure to the boot later. And comprising is followed by the body of the claim, which includes a frame, at least one fastening mechanism, and a propagation. So based on the independent claim, we can see that it is broadly written. Why would we consider this a broad claim? Remember, the USPTO assigns the broadest reasonable interpretation to all of the phrases in the claim. So a fastening mechanism could be any fastening mechanism like laces or ratchet straps or maybe hooks or a loop cloth like Velcro. So same with propagation mechanism. So it helps to refer to anything that helps move the boot forward. So it could be ice skates or four wheels in a quad formation or four wheels in a line formation, which means that the two skates on the left and the one on the left and the one in the middle, read on the invention on the right side and on the exemplified claim 1 that we talked about. So the two skates are considered prior art and appropriate for rejection for claim 1. So would this example claim 1 be considered on the bottom of the broad or narrow pyramid or in the middle? Let's take a closer look. So here's all the applicant's originally filed claims. And in order to overcome the two prior art pieces that we just mentioned, one of the questions that we're going to ask is, could the dependent claim really narrow down that independent claim? So let's take a look if we start adding the limitations from the dependent claims into the independent claim. These dependent claims further limit the independent claim by particularly claiming certain materials of the boot or the type of the propagation mechanism or the type of the fastening mechanism. So on the screen, all of the dependent claims would include all of the structure of independent claim 1 and then further limit these structures in claim 1. So based on what we read, let's go through and see how we can narrow the scope, okay? So when we add the wherein the propagation mechanism consists of four wheels attached to the frame, we can actually overcome the hockey skate because it actually has a blade instead of four wheels. Now also note that the transitional phrase here consists of four wheels. That means that there are not 3, there are not 5, but 4 and only 4 wheels. The independent claim is broad and can allow extra features to be added within the scope of the claim, but the dependent claim requires the exact use of 4 wheels. So when we add that dependent claim into the independent claim and we amend the claim language, it adds something that we can do to be able to make at least one skate be overcome. And so we look at this, a boot, ... frame, right? Now the claim reads, a boot comprising a frame, at least one fastening mechanism, and a propagation mechanism wherein the propagation mechanism consists of 4 wheels attached to the frame. And so now we have what we call overcome the hockey skate as prior art. However, we still haven't overcome what is in the middle picture, which is the quad roller skate. So what can we do? We can amend independent claim 1 further to overcome the prior art of the quad skate. So let's see what we have with respect to another dependent claim. So one of the dependent claim says specifically wherein the 4 wheels are arranged in a straight line. So if you notice that red X over the metal blade claim, that includes that particular claim, and that one now that it's included in the independent claim should be canceled. Okay, why would it be canceled? Because claim 1 requires the propagation mechanism consists of 4 wheels, and a metal blade is not 4 wheels, so this claim directly conflicts with independent claim. So why is the middle box gone? And why does the red line on the right change? Once a dependent claim is absorbed into an independent claim, applicants can actually cancel that dependent claim. So why is that? If claim 1 includes all the structure of claim 2 no longer further limits claim 1. So claim 2 is really just a repeat of claim 1, so claim 2 should just be canceled. And that other dependent claim on the bottom right, Since all the structure of the intermediate claim is now in claim 1, that bottom right claim needs to depend from the independent claim instead of the canceled claim. So let's go back and take a look at our full claim. So the claim reads a boot comprising a frame, at least one fastening mechanism, and a propagation mechanism, wherein the propagation mechanism consists of 4 wheels attached to a frame, and the 4 wheels are arranged in a straight line. So now the claim includes 2 different dependent claims, and now it negates all the prior art on the left, and we're left with just our invention. And so, as I mentioned before, this is what the independent claim is. However, there's one more claim cancellation that we need to make. Since the independent claim requires the wheels are in a straight line, that actually directly conflicts with one that is mounted in pairs. So that claim actually also needs to be canceled. And just like before, once a claim is absorbed into the independent claim, like the one at the bottom right, keeping that dependent claim is superfluous and therefore should also be canceled. We are now left with 2 dependent claims. One is the boot, wherein the plastic is a frame, and the other dependent claim is wherein the at least one fastening mechanism comprises a buckle. Those are 2 more, and these have more narrow limitations to basically exclude others from those particular inventions. All right, so now I'm actually going to be moving on to common issues with claim language, and these are things that our examiners see frequently. So the first person to pick up an application is actually the examiner. And so let's look at what the examiner does before issuing the first office action. First, the examiner is going to analyze the claim language, usually the broadest reasonable interpretation. And sometimes we refer to that as BRI, to actually determine the scope of the claim. And so during the examination, the claim must be given its BRI, consistent with the specification, as it would be interpreted by one of ordinary skill in the art. And so if the applicant has become their own lexicographer, meaning they have come up with a new meaning of a specific word, or they've created a new word altogether, the examiner actually needs to check the specification for those definition of terms. And because the applicant has the opportunity to amend claims during prosecution, giving a claim its broadest reasonable interpretation will reduce the possibility that that claim, once issued, will be interpreted more broadly than justified. Second, the examiner actually determines the metes and bounds of the claims and how clear they are. And so this really determines the scope of the claim. And if a scope is not clear, the claim will be rejected and considered what we call indefinite. A claim being broad does not necessarily mean that the claim is indefinite as to scope, but it can affect how the examiner actually interprets the claim limitations. So once the examiner determines the BRI and defines a scope, they will do what we call a prior art search. And once done, the examiner writes up the rejection, where he has to provide clear and sufficient explanation as to on the record as to why that claim limitation does not meet the requirements of the statutes required in the NPEP. So what exactly is unclear when the examiner reviews an application? So the 4 most common reasons for something not being clear is listed here. It can be that there is a lack of antecedent basis if there is an unclear or relative terminology, if there's exemplary language, and if there are improperly dependent claims. So let's dive deeper into each one of these issues. So let's go back to our example and take different claims associated with it. So let's talk about how these actually fall short. So we have independent claim 1 and then dependent claims 2 and 3. So claim 1 reads a boot comprising a frame, at least one fastening mechanism, and a propagation mechanism. And claim 2 reads the boot of claim 1, wherein said at least one fastening mechanism comprises a buckle, and the boot of claim 1, wherein the said buckle is plastic. So which of these claims is an issue? So the question is there a clear antecedent basis in the independent claim for the later referred to limitation? With claim 2, the answer is yes. It is also important to remember that the number of items being referred to must also be synchronized as well. But with claim 3, the answer is no, simply because claim 1 makes no reference to a buckle. It's actually written in claim 2. And claim 3 depends on claim 1 and not claim 2. So a quick fix to this is to change the dependency for claim 3 from claim 1 to claim 2. But for now, claim 3 is rejected under by an examiner under 35 USC 112B for lack of antecedent basis. So let's go to the second mistake that we often see, and that is relative terminology. And specifically, the claim recites the boot of claim 1, wherein the frame comprises a polymer-like material. So the question that we have to ask ourselves here is, would a person of ordinary skill in the art understand the phrase polymer-like? And so that depends. And so we need to go back to the specification and see if there is a special definition for the term polymer-like. And if there is, fantastic. We know what that term encompasses and what the scope of the term polymer-like means. But if there isn't a special definition in the specification, we now have a problem. So if there's just a list of polymers and then the specification says something from the list may be used, then we still don't know what polymer-like is. If the claim just says polymer, then that's okay, but the claim says polymer-like. So we're left scratching our heads on exactly what that means. So remember, the USPTO applies the broadest reasonable interpretation to all terms. That term that is not definite here is like, which broadens the scope of polymer, but the specification doesn't seem to define how much broader polymer can get. So as I just mentioned, by not having a definition of polymer-like, the claim would be rendered indefinite. In this case, it's best practice to actually just list out the polymers and polymer-like materials that are envisioned and listed in the specification. We recommend doing that rather than going with an indefinite and relative term by saying polymer-like. And so now we have an example of exemplary language. So the claim reads a boot comprising a frame, a fastening mechanism such as a buckle, and a propagation mechanism. And so the question to ask is the phrase such as a buckle. Is that clear as to the intended scope of the recited fastening mechanism of the boot? Does the claim require the use of a buckle? Well, no. A buckle is an example of a fastening mechanism, but it is not positively claimed. If the applicant defines the fastening mechanism to be a buckle, and that's really what they wanted it to be, then it would be better written to say a fastening mechanism comprising a buckle, because we then know that it is actually a buckle. But when you add the word such as, you render the claim indefinite because it doesn't really narrow down the claim. And again, as I just mentioned, exemplary language causes confusion, and then the metes and bounds of the claim are actually left unclear. So if an applicant intends to positive claim the terminology after a such as phrase, we recommend using comprises instead. So finally, we have improperly dependent claims. So improperly dependent claims most often result from amendments where a limitation has been moved, but anything previously dependent from the claim is not amended in the preamble. So in this example, we can see claim 2 was canceled, but claim 3 still depends on claim 2, which doesn't exist anymore. So in summary, some do's and don'ts, and starting out with do's and listed here. So some of the do's, particularly point out and distinctly claim the subject matter regarded as the invention. Consider drafting your claims first and then your specification based on the terms used in the claims. Make sure you review both to make sure necessary additions and corrections are made so that the claim terms find support in the specification. Look at the claims and the patents issued in your field of technology. Ensure each term has proper antecedent basis, and think about what legal protection you need for your invention and tailor your claims accordingly. So, some don'ts and some cautions. Do not use claims covering two statutory classes, a widget and a method, for example. Do not use terms inconsistently between the claims and or the specification. So for example, make sure that you're using the same term, whether it's visor, visor member, or visor section, or removable visor portion. It is better to use the same term consistently and as in both the claims as well as the specifications. Do not write multi-sentence claims. Remember, a claim is one sentence. Do not refer back to only a portion of another claim in a dependent claim. So for example, the widget of the apparatus of claim 1. Okay. And finally, do not replace elements from another claim within a dependent claim. So finally, I'm going to talk a little bit about the resources that we have at the USPTO, and then after that, I will open it up to Q&A. So the USPTO have a number of different resources. Apart from headquarters in Alexandria, Virginia, we also have 3 regional offices actually, which includes Detroit, Dallas, and San Jose. We recently announced the closure of our Denver office. And so we have regional offices still in those offices or those regions. The regional offices work closely with the IP community as well as startups and job growth accelerators. And so we're here to be able to provide resources to you and to answer your questions. We often collaborate with local science, technology, and engineering and math organizations on different outreach and educational programming. And so if you're interested in having your organization hear from us or have a presentation from us, please reach out and email the local regional office, and we can set up some consultations or set up a time for us to present to your particular office in that region. We also have great services available to the public, and a number of them are free. I can't stress enough that if you are stuck on where to go or who to reach out to, please reach out to our website or to one of the regional offices, because our website actually has a tremendous amount of resources that have been compiled, and it is very comprehensive. You'll be able to find the right place to answer all of your questions. And there are a number of 1-800 numbers that are actually also listed on our website. Please reach out to www.uspto.gov, free services. We also have a great resource called the Patent Pro Bono Program, where you can find information and get pro bono help in which there are volunteer attorneys who can be matched with you. The services that they provide are free of charge. In some cases, some of the pro bono organizations do have a small fee. Usually they're as low as $50. And so typically you'll have to just pay that. But the overall services provided by that attorney is free. And just as a quick reminder, even though that program may have free services for attorney's fees, you still need to pay your USPTO fees when you file your application. We also have law school clinics that allow law school students that are enrolled in the participating law school clinics program to practice before the PTO under the guidance of a law school faculty clinic supervisor. Those are either faculty that are with the university or they are practicing attorneys. So they are supervised by practicing attorneys. And so more information can be found at the link at the bottom of the slide. And then finally, we have many checklists on our website, and the two that would be most helpful with respect to filing your non-provisional utility application are listed here. We have a guide as well as a checklist, and the USPTO, just as a reminder, cannot assist you in actually drafting your application or your claims because that's actually considered legal advice. But we can explain the process to you and provide educational sessions like we have before. The checklist overlaps a lot of the information in the filing guide, but it's really a great resource so that you can find information in a succinct form. First-time filers are highly encouraged to review both the guide as well as the checklist before filing your patent application. And finally, here's just a list of resources that may be helpful for you as you're going through your patent journey. We have links to the application guide as well as the checklist that we mentioned before, but we also have a guide to patent searching, resources for different inventors, the Pro Se Assistance Center, as well as the micro entity information that we talked about before. And with that, I want to thank you for all of your attention. I hope that you truly enjoyed this presentation and walked away with information that is helpful for you.